Hi, everybody. This is Advocate Lucinda, your empowerment lawyer, and welcome to part 4 of my 12-part series on how to sue a police officer and its municipality for violation of your civil rights under 42 USC 1983. And today we're going to talk about the defendant's motion to dismiss and how to issue a killer response. So let's get started. The first thing I want to do is go over the grounds or reiterate the grounds for a motion to dismiss. What a defendant will assert. One, the officer will assert that he or she has qualified immunity. The individual police officer defendants are protected by qualified immunity because their conduct did not violate clearly established statutory or constitutional rights of which a reasonable person would have known. This is the defendant's assertion. Two, failure to state a claim under Monell liability. The defendant asserts plaintiff fails to allege facts showing an official municipal policy, custom, or practice implemented or ratified by C's Police Department, City of C's, the defendants in this case, that caused a constitutional deprivation. Third, they'll assert insufficient allegations, that the complaint relies on vague, conclusory statements rather than non-conclusory factual allegations required to cross the plausibility threshold under Ashcroft versus Iqbal and Bell Atlantic Court versus Twombly, 556 U.S. 662. It's a 2009 case. So let's talk about strategy. And you will hear me mention mirroring the defendant's brief. And that's what we're going to do. One, in mirroring the defendant's brief, you want to dissect the brief. After you have read the brief once, don't just sit it down and not read it until you get ready to do discovery, right? You want to immediately dissect the brief. Read it from top to bottom, or from the beginning to the end, thoroughly, and you will have to read it more than once to get an understanding of the defendant's defense so that you can properly respond. Number one. Two, read the case law in the brief. This is going to be tedious, but you need to read every case law that they cite. And why? Some reasons are to find bad law or wrong facts. For example, some of the laws will be outdated. The rules will be outdated. Two, the defendant may make bad quotes or quotes that are not accurate. I am not suggesting that the defendant would do it intentionally, but you just need to read the brief to make sure that if such is included in the brief, that you address that later on in your response. And in opposite facts, for example, we know that when we're citing a case, we want to get a case with facts generally similar. They don't have to be exact, as we will see later on in the demonstration. But facts that are so in opposite to plaintiff's facts, plaintiff would argue that they should not be relied upon, or the brief should not be relied upon. Or put another word, the court should not rely on this case cited by the defendants in support of their position. It will also help you find, by reading the brief, you will find helpful text. The case that the defendants cited might include good rules. The court's reasoning in that case might support your claims. Exceptions. The case may note an exception that saves your claims. What to look for? Look at the facts of the defendant's case, as I stated earlier. Compare those facts to your case. Check the holding or final rule the judge set. And 3, copy the brief to Word format. If you have not done it already, be sure to copy your brief to Word format so that you can really do mirroring conveniently. Let me show you what I mean. This is a sample of the defendant's motion to dismiss. You see the caption here, Lucinda Jones versus Seas Police Department et al. Defendant motion to dismiss plaintiff's complaint. Come now, the defendants, Seas City Police Department and others, and file collectively their motion to dismiss plaintiff's complaint. And they state the grounds for the motion. 1, qualified immunity. 2, failure to state a claim under Monell. And 3, insufficient allegations. The memorandum of points and authorities, the legal standard. And this legal standard is used both by the defendant and the plaintiff, so that language never changes. It's just how it's being used. To survive a motion to dismiss under Rule 12b-6, a complaint must allege enough facts to state a claim to relief that is plausible on its face. They cite Bell versus Twombly, a 2007 case. A claim is plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged, and they have cited Ashcroft. These 2 cases are precedents, and again, both parties use them to set their position. And then the defendant finally says, to survive a motion to dismiss under Rule 12b-6, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Then they say plaintiff has failed to plead a plausible claim. And we're going to see when we respond how the language is going to be framed for the benefit of the plaintiff. We're mirroring now, okay? This is part of mirroring. The point with mirroring is that you are going to read what the defendant states. If it is opposite to your facts, then you're going to mirror them by simply replacing them with your facts, okay? Now, you'll see when we do plaintiff's response to the defendant's motion. Okay, so they state the facts. And I won't read the facts, but I do want to go to certain parts of it. The first sentence, the plaintiff filed this 42 U.S.C. 1983 lawsuit against the defendants for allegedly violating her due process under the Fourth Amendment of the United States Constitution. Then they cite where that information was stated. Plaintiff's record 1, which is the complaint, paragraph 4. Now, depending on the circuit, they may want you to use a certain type of citation. There are various ways you can cite these, and just make sure that they comply, okay? And so you have another statement here where they reference defendant's record 1, which is the brief, page 15 to 20, okay? So let's get to the argument. The individual officers are entitled to qualified immunity. Now, let me just say this right now. This introduction, you're simply going to mirror that. They say that they are entitled to qualified immunity. You just mirror it by stating the opposite. For example, the individual officers are not entitled to qualified immunity. I want you to get what I mean when I say mirroring. Make it easy for yourselves, okay? Because the defendant has set the path, and all you have to do is follow it and correct it as you go along, okay? And they state, plaintiff has not identified a specific well-established constitutional violation committed by Officer Harold Jones under the specific circumstances alleged. And they go on, qualified immunity protects government officials unless their conduct violates clearly established statutory or constitutional rights of which a reasonable person would have known. And they cite the case. Okay, and they go on and they continue addressing their position. Okay, the second topic, the municipality cannot be held liable. Under Monell versus Department of Social Services, a municipality cannot be held liable under Section 1983 on a respondent superior theory. Plaintiff fails to establish a direct causal link between a municipal policy and the alleged harm. And you're going to see how we're going to respond to that, mirror it, and state just the opposite of what the defendants have stated and establish it with two things, with plaintiff's facts and with law, case law. And then defendant concludes it. For the foregoing reasons, defendants respectfully request that this court grant this motion to dismiss and dismiss plaintiff's complaint in its entirety with prejudice alongside any other relief the court deems equitable and just. And then they, of course, cite their information where they can be contacted. Now, this is the plaintiff's response to the defendant's motion to dismiss. You see the same caption here, except it's going to be plaintiff's response to defendant's motion to dismiss plaintiff's complaint. Comes now, plaintiff pro se and respectfully request that this court deny defendant's motion to dismiss. Plaintiff responding to the defendant's position that plaintiff has not pled sufficient factual matter. Plaintiff is saying here, plaintiff has pled sufficient factual matter to state a claim to relief that is plausible on its face. See, plaintiff is again citing Bell, Wright, and Ashcroft because they both work for either side depending on the side's position. So let's get to the memorandum of points and authorities. We're mirroring, right? So in the plaintiff's legal standard, she pretty much states But the standard is, it's always the same. The standard is always the same. So plaintiff cites Bell here, and then Ashcroft, right? Okay. She states to survive a motion to dismiss under Rule 12b-6, a complaint must allege enough facts to state a claim to relief that is plausible on its face. Citing Bell, she understands, she agrees with the defendant. She's not arguing that, but she is stating here a claim is plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The same standard, but see how the plaintiff is stating it in a way that's favorable to her case. And she says, crucially, at the motion to dismiss stage, the court must accept as true all of the factual allegations contained in the complaint and draw all reasonable inferences in the plaintiff's favor. And she cites a case law here to survive a motion to dismiss under 12b-6. A complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. See how she is using again the law and recounting it in a way that is favorable to her case. Plaintiff complaint has met this threshold. Mirroring the defendant now has said just the opposite of what the defendant has said. Now, she states her facts, but it's critical that you're going to state the facts that you use to defeat the defendant's version of the state of facts and their overall position that the plaintiff failed to state facts sufficient to state a claim for relief. And I want to go through these one by one. On July 31, 2026, defendant Officer Harold Jones stopped plaintiff, raided her vehicle in the city of C. She shows the court where that can be located. That's critical now because this is the kind of language needed to state a claim, all right? Officer Jones was operating the C City Police Department vehicle, and he was fully dressed in uniform. ID, again, she is, well, let me go back here to the end of the first sentence. R is record 1, which is plaintiff's complaint, paragraph 1. Okay? So let's go back to the second sentence where we see ID just simply means I'm referring back to record 1, but it's paragraph 2. Are you following me? Okay, Officer Jones asked plaintiff, where are you going? Plaintiff explained that she was lost and showed him her phone as evidence that she was lost. ID again, plaintiff's complaint. You can find that in plaintiff's complaint. Sorry about that. At paragraph 3. Officer Jones asked other questions to which plaintiff answered. Officer Jones then asked plaintiff to present her license. Again, where can that information be found? At the complaint, record 1, plaintiff's complaint, paragraph 4. Because remember now, the causes of action have certain elements, and those elements have been met. So you'll see later on when we get into the argument. Okay? And she states here she complied. Officer Jones verified plaintiff's identity and determined that she had not committed a crime. Nevertheless, he detained her for 2 additional hours before he released her. Again, record 1, plaintiff's complaint, paragraphs 5 and 60 is where that language can be located in the complaint. Because remember, it's all about the complaint. The complaint has to state the claim sufficiently, right, where the case can move forward and not be dismissed because it failed to state a claim upon which relief can be granted. So here we go, the argument. Plaintiff has stated causes of action upon which relief may be granted. Because remember, defendant's title was plaintiff has failed to state a claim upon which relief may be granted. Okay? 1. Officer Harold Jones is not entitled to qualified immunity. This mirrors the defendant's heading that they are entitled to qualified immunity. Defendants contend plaintiff has not identified a specific well-established constitutional violation committed by the officers under the specific circumstances alleged. Now, she's referring to where that can be located because she's going to mirror what the defendant said. And so the court need to be able to go back if they need to and read that and see how the plaintiff refuted that. Qualified immunity protects government officials unless their conduct violates clearly established statutory or constitutional rights of which a reasonable person would have known. And she cites Harlow. To defeat a qualified immunity defense at the Rule 12b6 stage, the plaintiff must satisfy a two-pronged test by plausibly pleading, going back to the complaint, that the official violated a statutory or constitutional right, and 2, that the right was clearly established at the time of the challenged conduct, citing Ashcroft. Because qualified immunity is an affirmative defense, dismissal under Rule 12b6 is only, you see what she's doing here? Appropriate if the defense is clear from the face of the complaint itself. If the complaint contains sufficient factual allegations to make the violation plausible, the motion must be denied and the case must proceed to discovery. And you'll find that language in Ashcroft, and I probably should have put an ID here. The Fourth Amendment of the United States Constitution prohibits unreasonable searches and seizures. Officer Harold Jones violated the law after he determined that plaintiff had not committed a crime and nevertheless held her for 2 additional hours. Does that language sound familiar? It was stated in her complaint, in plaintiff's complaint. And then she cites a case to demonstrate it. In Rodriguez versus United States 575 U.S. 348, 2015, the United States Supreme Court ruled that a police detention becomes unreasonable and violates the Fourth Amendment the moment an officer prolongs a traffic stop beyond the time reasonably needed to complete its initial mission. The Supreme Court found that the officer in Rodriguez completed the standard traffic stop procedures, which included checking the driver's license, running a registration check, and issuing a written warning. However, after completing the stop or mission, the officer ordered the driver to turn off the engine and wait for a backup unit so a canine dog could sniff the vehicle. The dog sniffed occurred roughly 7 to 8 minutes after the traffic citation was already issued, ID referring back to the Rodriguez case. Similarly, you see the connection, we're making the connection. After Officer Jones viewed plaintiff's license, questioned her, and determined she had not committed any crime, he had completed the mission. Nevertheless, Officer Jones continued to detain plaintiff for 2 additional hours before releasing her. Plaintiff's complaint has met the qualified immunity threshold. This is called mirroring. So let's go to the defendant's next contention. 2, the city of C's municipality is liable. Remember, the defendant said that it was not liable. Defendants contend plaintiff fails to establish a direct causal link between a municipal policy and the alleged harm. And here's the record 2 where the defendant's contention can be found. Record 2, defendant's brief, page 1. Under Monell versus Department of Social Services, a municipality can be held liable under 1983 when the municipality's official policy, custom, practice, or usage caused the constitutional injury. And she cites Monell versus Department of Social Services, 436 U.S. 658. C. City Police Department is liable for the unlawful seizure because the acts, omissions, policies, and customs of defendant City Police Department and Officer Jones constituted deliberate indifference to the constitutional rights of the plaintiff, directly and proximately causing the deprivation of her right described herein. And the plaintiff is going back to their complaint, record 1, the complaint, paragraph 64 to 65, because remember, to survive a motion to dismiss, the proof that the plaintiff has established plausibility, it has to be stated must be stated in the complaint. And that's why plaintiff referred back to the complaint to let the court know that she has met that threshold, her requirement to state, I don't like this information, okay? And plaintiff continues, for example, the police department and Chief Smith culturally winked at officers' misconduct, including Officer Jones's, and the department failed to train on policies concerning police conduct, misconduct. Plaintiff cites it again, ID, telling the court to go back and look and see where I have established the plausibility. Then she ends, plaintiff complaint has met the municipality threshold. For the foregoing reasons, plaintiff respectfully requests that this court deny defendant's motion to dismiss. And you state, submitted, the date it was submitted, your name, address, phone, email, and don't forget the certificate of service, okay?